Mr. Lobel, isn't the real reason why we have to keep the Kurtz avenue narrow is because if you don't do that, you end up end-running Congress's intentions with respect to enacting the FSIA. That we have a statute that Congress, as Justice Kagan said at the beginning, thought about the universe of claims that could be brought against foreign governments, said we don't want this being done in an ad hoc fashion anymore, so we're going to create a statute that lays out what we, the court, has said subsequently is the exclusive way in which you get to sue a foreign government. Kurtz comes along, and we see this kind of one circumstance in which we might conceive of an exception to application of the statute that Congress has created for this purpose. And it is this dead letter, if you have a cause of action, but there's no way you could ever, abrogate sovereign immunity or a cause of action against a government, but you could never recover. Then you go, okay, that really does have to be interpreted as a situation in which Congress did intend for sovereign immunity to be abrogated, notwithstanding the FSIA. But if you get broader than that, if we're in 99% of the cases, 97%, 97%, then you could have a rule operating outside of the FSIA to do the very thing that Congress didn't want the FSIA or didn't want to have happen, which is why it enacted the FSIA. So this exception has to be like really tiny, or else we don't give effect to Congress's expressed intent to have the FSIA be the exclusive avenue for abrogating sovereign immunity.
Exactly, Your Honor. Exactly.
Well, the FSIA may have been the exclusive avenue when the FSIA was enacted, but the Congress that enacted the FSIA does not have the right to control what later Congresses do.
Correct.
So
And that's Justice Gorsuch's point, right? Later Congresses can say with respect to each statute, this don't apply the FSIA here, and they can say that. But what's happening here is that we are now implying that later Congresses intended that. With that language doesn't appear in this statute, but we're having a 2-hour argument as to whether or not we should interpret it. And I don't understand that.
Right. And it's not any magic words. They just need to.
I think Justice Alito had a question.
Oh, sure.
That's all right. Go ahead.
Okay.
Well, just one last point. They claim that you can harmonize the statute, the two statutes, by reading a tiny exception into the FSIA. And I agree with Justice Jackson that once you start reading that tiny exception in, it will expand. Camel's nose will be under the tent. But that does not harmonize these two statutes. The rule that specific can override a general, in this context, doesn't apply when there's an implied repeal question. Their reading of the statute is that you have a narrow exception, a narrow repeal of the FSIA, and that's still an implied repeal. As this court said in Home Builders, it doesn't matter whether you call it an exception, an amendment, an implied amendment, it's still an implied repeal. And it contradicts the FSIA. The FSIA 1604, section 1604 says, foreign states shall be immune unless one of the exceptions apply. They want to read the statute exactly how, Justice Alito, you didn't allow them to read the statute in Home Builders. Just add another exception. Just add another criteria which is not in the statute.